Okay, good morning.
Morning, Judge.
Okay, Mr. Martinez, Mr. Steinberg, I'll go ahead and introduce you to the other members of the panel. We have Judge Meredith Sasso and Judge Dan Traver. Do want to advise you that these oral arguments are being streamed on YouTube so that the public does have access and can watch the arguments. You should be able to see a clock on your screen. Is that correct?
It is.
Okay. So, Mr. Martinez, how much time would you like to reserve for rebuttal?
5 minutes, please.
Okay. And Mr. Steinberg, since you do have a cross appeal, you can reserve any part of the 20 minutes for rebuttal solely on that issue, on the issue of your cross appeal, okay?
Yes, Your Honor.
Okay, Mr. Martinez, you may proceed.
Good morning, judges. So this case involves ostensibly a dispute between two law firms on who is entitled to what portion of the fee. And while it involves some relatively complicated issues of law, the facts, they're lengthy, but they're relatively straightforward. And ultimately what happened was the court nullified a jury verdict finding zero damages despite a finding of breach with highly disputed evidence supporting essentially both sides on that issue. The jury instructions in this case, when you look particularly at jury instruction 7, and I'll be talking about that one some more, are inconsistent with the standard, in our view, that the judge applied on DV after the verdict. And of course, it also involves a directed verdict on a closing statement, which we contend was a valid modification. And then, of course, this case also involves an award of prejudgment interest. On the first issue, the directed verdict nullifying the jury's verdict, the court, the way that we got here, and it all has to be premised on the context of the case as it evolved, the jury, of course, saw the modification, and the jury saw all the evidence that was involved, and the jury also saw the rules regulating the Florida bar, not because they were asked to pass judgment on those rules. It is our position that that is for the bar and for the court, but rather because those rules were incorporated into the contract. And those rules required a specific level of performance, which we contended Maria Gerber did not meet. As we approached closing.
Were they provided a copy of the rule, or was it just presented in the context of testimony?
Well, both. So it was primarily presented in the context of testimony, but the specific portions of the rule that we refer to were actually recited in the petition and the employment agreement. And of course, the jury had those two things. In addition to that, the salient portions of the rule were used as demonstrative aids during the trial. But in terms of exhibits, they did have the salient portions of the rule in the actual contract. And I can cite to the court to that record just momentarily, that portion of the record. In any event, after hearing the testimony, the court granted a directed verdict, and in jury instruction number 5, it told the jury the following: the employment agreement required Harmon Parker to divide the attorney's fees with Gerber Law Group. That was a result, of course, of the DV on the closing statement. It's not a modification. Therefore, I'm instructing you that the employment agreement required Harmon Parker to divide the fees. So it is our contention that that was essentially an advisory opinion. We don't take issue with the instruction as given. Rather, we take issue in application subsequent to this. And so once the jury is told, look, I'm telling you right now that the agreement required these two firms to divide the fee, it seemed that it was pretty likely that a breach was going to be found in terms of Harmon's obligations. The remaining question was, what were the damages? And then there was a lot of evidence on what those damages could be. You know, Gerber contended, I get the full 1.67 million. Harmon contended, well, you don't, because your performance didn't rise to the level of what you promised. And that promise was contained within the, not only within the bar rules, but also within the agreement itself. And that promise was for equal active participation. There was a lot of evidence on that, on whether or not Ms. Gerber equally or actively participated. She did have, her law firm had the
What
file.
was equal active participation in the agreement? I know it was in the petition, but that y'all filed with the court, but was it in the agreement?
I don't know the answer to that. For sure, it was in the petition. I'll have to,
Or you can ask that during rebuttal if you want to look at it.
yeah, I'll get that for you. But in any event, the employment agreement did cite to the rules regulating the Florida bar as providing the obligations. And so whether it was in there or not, we do think it's important, and we do think that it does apply. And in fact, Maria Gerber testified that it applies. When she testified to the jury, she did say it required that. Whether or not there was equal or active participation raises the question of whether or not these rules contemplate her participation before the referral and the participation after. You know, the Katz opinion draws a pretty bright line there, and the facts are simpler in Katz because it was simply, here's a case, can you take it? This case is a little different because Ken Gerber, Maria's husband, initially got the case and started on it. However, the evidence that the jury heard was that Ken left the firm, Maria had it. She was not equipped as a lawyer at this stage in her career, given her experience, to handle this kind of case, and she candidly admitted that. And she acted, the import of the evidence was that she acted more as caretaker counsel, and and that her level of performance was within a reasonable standard perfunctory. For instance, after filing the complaint, she asked her brother to attend one deposition. That deposition was of the tortfeasor, and that deposition was set by the tortfeasor's lawyer, and the only questions asked were those questions that would get him a summary judgment on liability. No questions were asked at that deposition by the plaintiff. That cannot be characterized, even if we bring in...
Beyond the factual dispute, just in focusing on the legal issue, this was all presented to the jury, though, in the context of whether she performed the contract, though, correct? In terms of the way that the evidence was structured and closing argument was structured. So what is your response to the argument that this is all subsumed into the jury's finding that she substantially performed under the contract?
Because when the court instructed the jury in instruction number 5 that Harmon Parker was obligated to divide the key, we think breach was pretty much a foregone conclusion at that point. And the instruction, if you look at how the jury was told to evaluate this, it's broken down into 4 elements. And it's premised with to recover damages for a breach. Gerber has to prove the following, and then it's got 4 elements. One of those 4 elements was that Harmon Parker failed to do something essential. Well, the court had already instructed the jury that that was the case. That left elements 1, 2, and 4. Element 1, which was left for the jury to decide, is whether Gerber did all or substantially all of the things that she was required to do. The second one was whether...
So if I understand your argument, that she did everything she was substantially required to do, are you arguing that the terms of the employment agreement would have allowed the jury to find that she complied with the agreement, but that because her performance in representation of the client was not substantial, that the agreement contemplated she receive a lower fee?
Yes, it was.
And so what specific term that the jury saw in the employment agreement would support that argument?
The incorporation of the rules regulating the Florida bar, as well as her testimony of her own understanding of that agreement and her obligations. And she testified that she would be limited to 25% unless she equally and actively participated. And that gave the jury...
And you mentioned that record site. If you could also on rebuttal provide us with that record site.
Sure.
Sorry, go ahead.
On equal and active, her testimony on equal and that the contract required that, or that those were her obligations?
Yeah, well, I'm referring to the specific term of the contract that the jury would have seen, and you mentioned that the jury saw the contract incorporating the rules regulating the Florida bar and a copy of the rules, and so I was just looking for that record site. There's several versions, I think, of the same agreement in our record, so I just wanted to make sure that we're looking at the same page.
Right, and it is also, part of our argument is also that any contingency fee agreement, as a matter of law, incorporates the rules regulating the Florida bar on contingency fee agreements. So that is also an assertion that we make, but I will find those for you for rebuttal.
Well, in this case, did your client and the Gerber firm comply with the rules?
No, not both. Certainly Gerber was insufficient in terms of not providing a sworn petition in terms of what performance she was going to be giving. And one of the reasons that
Well, the petition was unsworn, correct?
it was.
So
It was.
neither party complied with that requirement.
Correct. And under
The
CAT,
petition was required to be signed by both counsel. It was signed by your client, but not by Gerber, correct?
precisely. And at the hearing,
The petition was required to disclose in detail the performance to be performed by each counsel. Both sides failed in that regard, correct?
correct. That's
And
correct.
assuming that the agreement did not reference the obligation of substantial equal participation, and assuming, as we know, that Ms. Gerber or no one from Gerber signed the petition, then that obligation was not complied with as well, by Gerber at least, correct?
I'm sorry, I lost the assumptions. Assuming that Gerber did not sign the petition,
Well, Gerber did not sign the petition, and assuming that the agreement that both parties would have substantial equal participation, assuming that was in the petition but not the contract, and given that Gerber didn't sign it, that would mean that Gerber didn't comply with that aspect of the rules as well, correct?
she did not, although the jury did hear testimony from Gerber that her understanding was that those were her obligations. And
Right, but the
still-
rule requires it to be kind of written to the court, right? I
Precisely.
mean, you got to advise the court, not just have an understanding, not put it down on paper, correct?
Well, you do. And it's important, of course, because of a case like this where you have two lawyers later arguing over what they were supposed to be doing and the level of their performance. In that case, Katz mandates that the court just leaves the parties as it finds them, and you can't come in and seek relief, of course. That would be consistent with reinstating the verdict in this case. There was ample evidence that Maria Gerber, of course, didn't perform as the parties anticipated, and she effectively testified to that. In terms of jury instruction number 7, though, the jury was instructed that in order to recover damages, you still need to find that she didn't substantially comply. By finding that there were no damages, that's consistent with the evidence at trial that she did not comply, as she explained in terms of her own duties. For that reason, we think that the verdict was appropriate. Judge Carroll, in looking at this, looked at this, it appears from, and I was there during the hearing, and of course I've read the record, and I didn't completely follow the logic, but it appears to me that when you look at the 4 elements that were in the jury instruction, what they were told to follow, he took element number 3, which is that Harmon Parker failed to do something essential. We believe that's how the jury found a breach. But there were still these other 3 remaining questions, and he effectively decided for the jury what those other 3 questions were, is how we're reading this. And because of that, we get back to, and I'm looking at Judge Carroll's statement during the hearing. He said there's no view of the evidence or any reasonable inference of the evidence that would support the defendant's position that the 390 was not owed. In other words, that it had to be split 1.67 each. We disagree, of course, given all the evidence that's in the record, and because of the way that the jury was instructed to analyze the issue. They analyzed this issue, it seems, differently than Judge Carroll did. And so because he instructed them in this specific manner, we think that their verdict has to be viewed and analyzed in the same manner when the court's looking at it for DV, and we believe he made a mistake when he didn't analyze it the same way. There are more jury instructions that support this, and the charge conference in this case was 8 hours. It was long. The attorneys and the court were trying very hard to get this thing distilled and make it as simple as possible, but there are other jury instructions that support our argument, which is that this issue was left for the jury. For instance, jury instruction number 13, the court said, if you find for the plaintiff, Ms. Gerber, you should award her the amount of money that the greater weight of the evidence shows will fairly and adequately compensate her. So even if they find breach, they are to award what they think is fair. There was evidence that she had been made whole, right? There were these subsequent payments that were made. And then there was the whole issue where she acknowledged that she has to qualify for greater than 25% by equally and actively participating. And there was plenty of evidence that she did not meet that threshold. So there was a sufficient evidentiary basis from which the jury could conclude, look, you said yourself you're maxed out at 25%. Then we've got this jury instruction number 14 that says award her what she earned. And then of course, 25% from the total, there was evidence that she had already obtained that amount. Jury instruction number 15 says that to recover damages for breach, plaintiff must prove the amount due under the contract. And that is an alternate basis and an alternate reason why the jury may have come to a zero verdict. And of course, I don't need to repeat all the evidence. I know the record's long, but there was certainly disputed evidence on whether or not she met more than equal or active participation. Even if under the bar rules, a court determines that her level of performance, I mean, initially our position is that equal and active participation was promised at the time the co-counsel relationship was formed. However, even if you go back and you include the work that was done prior to that, there was sufficient evidence that even that could reasonably be viewed as merely a perfunctory effort on her part, which would not rise to the level of what a reasonable person could think. That didn't rise to the level of reasonable, active participation. In any event, let's see. Jury instruction number 16.
Down to 4.5 minutes, Mr. Martinez.
Thank you. Jury instruction number 16 on that same topic says the court instructs you that if you find a breach relating to the failure to pay the fees, and if you award damages. And so the jury's being told they've got the option here. And we believe that these jury instructions were correct given the evidence at the time. And for those reasons, we think there's more than a sufficient evidentiary basis for the jury's finding. We do not believe that it should be disturbed. On the issue of the modification, the court looked at the Lugassi case, which indicates that, hey, a lawyer cannot, after a verdict, change the terms and obtain a windfall, even with client consent. Judge Carroll, in this case, analogized that case.
Putting Lugassi aside, though, just as a matter of contract law, is a settlement statement ever considered a new contract? Isn't it just an expression of previously agreed to terms typically?
Well, I think it can be either. And I think in practice, it commonly is either. It is common, and there's record evidence of this in terms of affidavits, but it's common for lawyers to change their fees. Usually, well, every time I've ever seen it, it's to the downside. It's common for lawyers to reduce their fees in order to get a case done. And we see that, and I think that's common practice throughout the United States. And
I think common and probably typically not challenged. But in the case where I think you're essentially arguing that this was a modification of the contract, do you contend that just by signing the settlement statement that from a matter of contract law, that all the elements necessary to establish a modification to a legally binding contract were presented in this case?
Yes, yes. And the reason is the context. You have to remember, by the time of the last mediation, and this came through testimony through Gary Wiseman, who was the bad faith lawyer who had been brought on. Gary Wiseman testified to the jury that he recalled that Ms. Bryan, the client, was very upset with Maria Gerber because Ms. Bryan believed, rightly or wrongly, that Maria Gerber had compromised the case through her handling of it. And there was talk of a malpractice action, particularly coming, not an action, but there was talk of malpractice from the insurance company on the tortfeasor side saying, hey, you guys are not going to be able to establish liability. And these were open questions at the time. There hadn't been motions in limine, so on and so forth. So at that point, you've got a client who's very upset with Maria Gerber. You've got Tom Harmon, who's trying to do what he can to salvage a settlement. And when they get the chance, it is settled. And then come the post-settlement talks on how we're going to divide everything. And at that point, Gerber had every incentive to buy peace with the client. So we do think there was consideration there. She had every incentive to buy peace with Tom Harmon because Tom Harmon believed that he had been misled as to the status of the negotiations before he was brought on. He thought that the carrier had already essentially admitted bad faith, so we're not going to need bad faith counsel. We're just going to go in and talk about the tort value. And he found himself in a position where apparently that was not true. And whether Tom Harmon was mistaken or not, that's what he believed. And therefore, we do believe there was valid consideration. Now, later, there's even more evidence of that. Later, of course, all of those issues got resolved between the client and Maria Gerber and Dale Swope's firm. And there was a release which actually said for legal malpractice. And that was an exhibit that was shown to the jury, and they saw that. There was evidence that the $730,000 she directed be paid to Mr. Swope's firm, of course, to help resolve that entire issue. So all of that evidence that came in for the jury later is evidence of the consideration that was being used or that was there for the closing statement. And because of that, we do believe that it was a modification. I don't think there's any logical reason that a closing statement could not function as both. And I think that it's common for that event to occur in Florida. I see that I've got 5 seconds left, so I'll say thank you.
All right, I'll give you 1 minute for rebuttal, Mr. Martinez. Mr. Steinberg, I'll give you 21 minutes. You may proceed.
Thank you, Your Honor. May it please the court? Brent Steinberg on behalf of the appellee, Cross Appellant Santec Management LLC. Your Honors, there's 2 sets of numbers, 4 numbers in total, that I think it's absolutely critical that we keep in our mind here. And I know that there are a lot of numbers flying around, so it would be my suggestion to you that you might want to write down these 4 numbers. And you can think of it like on a T chart, where on one side you have what was owed under the contract, and on the other side you have what was actually paid. And Gerber, under the contract, was entitled to $1.67 million. That's the first number. And she only received $1.28 million. That's the second number. Harmon was entitled to a maximum of, third number, $1.49 million. And I say maximum because Harmon was also contractually obligated to satisfy the Swope lien, whatever it was. But assuming that was worthless, at most he gets $1.49 million. And then the fourth number, what he actually got was $1.58 million. That's the amount that Harmon paid itself out of its trust account without a fully signed closing statement. So Harmon paid itself an additional $90,000, which it has to this day, and deprived Gerber of $390,000, which was been owed since January 2010. That was the undisputed evidence, that on January 20th, 2010, Harmon paid itself $1.58 million, immediately disperses almost all that money to himself and to his partners. Harmon also withheld nothing for the Swope charging lien, which the trial court held was improper, and then paid $300,000 to an attorney named Gary Weissman, who didn't even have a valid contract. And it wasn't until January 25th, 2010, that Harmon presents Gerber with a closing statement. By then, Harmon only had $1.28 million set aside in the trust account to pay both Gerber and Swope. But under the contract, as we said, Gerber was entitled to $1.67 million, and Swope's charging lien was claiming to be entitled to $1.185 million. Well, you can't pay out $2.7 million if there's only $1.28 million left in the trust account. And that is what set in motion a decade of litigation between Harmon, Gerber, Swope, and to some extent, the Bryan family.
Mr. Steinberg, on the modification, one of the arguments you made, I believe below and certainly on appeal, was that it was void or there's no basis for modification because of non-compliance with the Florida Bar rules, particularly the same section that they're alleging, or they've made the argument, renders the whole contract void. So what is the distinction between your argument that the modification is void because it didn't comply with the Florida Bar rules, and particularly 4-1.5 F4D, and your argument in your answer brief that the modification was void because it didn't comply with 4-1.5 F4D? Good
question, Your Honor. So the modification was void for multiple different reasons. It was void because Gerber didn't have a contract with Gary Weissman, so she never became contractually obligated.
I want to focus on your argument that it didn't comply.
Sure. So there was never a proper contract between Gerber and Weissman that complied with Rule 4-1.5 F2, which requires that all the contracts be in writing and everything has to be agreed to before the contingency fee occurs, which is why post-settlement modifications are void as a matter of law under the Lugassi case, under the Katz case, and others. But the distinction between why that was void and why our contract isn't void is because we're talking about actually two different rules here. What Your Honor is referring to is Rule 4-1.5 F4D subsection 3. That's a mouthful.
Correct.
But that is the part of the rule talking about the fee approval process. And the rule doesn't cap anyone's fees at 25%. It's just talking about a presumption of excessiveness. It says
Right. But that rule, but your argument on the modification being void was that it was not submitted for court approval, which was required by the rule, correct?
Well, that was certainly part of it. Yeah. The contract itself.
All right. Well, but your client was also, as far as the underlying contract, because of the nature of the fee schedule, it was required to be submitted to the court for court approval, correct?
Not exactly, Your Honor. So my client.
Didn't it exceed the scale?
Well, no, because Maria Gerber and the Gerber Law Group wasn't the secondarily responsible firm in this context.
Let me get into that. I'm talking about the overall, because it was 40%, even if it was 10 million, 20 million, whatever the verdict was, that exceeded the scale set by the Florida bar rules, right?
You're correct that the 40% contingency fee that was being charged exceeded the scale that is set by the Florida bar
So it
rules.
had to be submitted for the court approval, right?
But yes, that court approval is necessary to ensure that there's no presumption of excessiveness.
Okay, and that petition for approval has to be sworn to, correct?
The rule says that, yes, Your Honor.
And it wasn't sworn to here, correct?
It was not by
It
either
has to
party.
be signed to by both counsel, correct?
Rule says that.
Wasn't signed by your client.
It was not signed by Maria Gerber.
Has to provide in detail, disclose the acts of performance to be performed by each co-counsel. That wasn't done here, correct?
The petition did not do that.
Okay. The contract didn't do it either, did it?
No, I don't believe so. Not in detail.
Okay. And there also has to be an agreement of substantial equal participation by both counsel. And that was, if I recall correctly, not an agreement. And certainly your client didn't sign the petition saying that, correct?
There was never an expectation that Ms. Gerber was going to be providing substantial equal active participation moving forward. But in the petition, it does say that considering the entire course of the representation, that the two counsels would be providing substantially equal.
Yeah, but your client didn't sign the petition, so she wasn't bound by that, right?
Well, yeah, that's correct.
So in what way did your client in fact comply with that rule? I mean, you say that, in your supplemental brief that any violation was minor and technical. And I've gone through at least 4 areas where they didn't comply. I'm trying to figure out what area there was compliance.
Well, the petition certainly had its difficulties, but I think it's important to, let's just assume for the sake of argument, that the petition to approve the contingency fee contract was invalid as a matter of law. Or in spite of that, the court still did approve the petition to approve the contingency fee contract. That order was never challenged. So for purposes of this appeal, we just have to take it as fact.
Well, the rule specifically provides that the initial approval is not the end of the story. There can be a subsequent review, right?
That is correct. But the order approving the contingency fee contract is still in effect. So the contract was approved despite all of the errors in the approval process that Your Honor is referencing. But, so let's just take it that the petition was void as a matter of law. What would happen if we play that out? Well, Gerber would still be allowed to represent the Bryan family, could even still charge the same fee. The denial of the petition doesn't change the terms of the contract. It would only mean that there would be a presumption that the firm who is assuming secondary responsibility would be getting an excessive fee.
Well, actually, the contract, because the nature of the contract, it requires the petition and court approval. So doesn't that affect the underlying contract as well?
But
Because otherwise you have a contract with requiring the Bryans to pay an excessive fee.
and there was court approval in this case. So at least for purposes of the contract, that part had been satisfied. The thing here that Harmon is asking the court to do, which it can't do, is to make the factual determination of whether or not there's an excessive fee, or whether or not Gerber or Harmon would be the secondarily responsible firm, or whether or not there would be evidence to overcome the presumption of excessiveness if we ignored the fact that the court in the personal injury action did in fact approve the petition. And that would be asking this court to sit as a fact finder, which no appellate court is supposed to do. Those are questions that most likely would have been for the jury, and Harmon waived any right to that because he didn't ask the jury to make any of those determinations. Harmon's also not asking that this case be remanded for a new trial. Now, if we say that these are legal questions that the trial court should have weighed into, then Harmon still isn't asking for this court to remand for the trial court to make those factual determinations of whether or not there's a clearly excessive fee, or whether or not Gerber or Harmon was the secondarily responsible firm, or even whether or not there was substantially equal active participation. There was no ruling from the trial court on any of that. So there's no decision for this court to review. And Harmon isn't asking for the court to remand to the trial court to make that determination. Harmon's just asking this court to find as a matter of law that Gerber's fees were excessive and enter a defense judgment. And respectfully, the court can't.
Steinberg, let me ask you this. In Chandris, the Florida Supreme Court talked that one of the purposes of the rules was not only to protect the client, but also to have attorneys follow the rules, so that the attorneys that did follow the rules were not at a competitive disadvantage with the attorneys that didn't follow the rule. So in this case, one could certainly view the facts as certainly an argument can be made that your client was, getting 25%, more than 25% was not in compliance with the rule, and that would, cause a competitive disadvantage as far as those attorneys who did follow the rule, and if they weren't going to substantially equally participate or agree to that, at least to the court, and disclose to the court the acts that each counsel would perform, that those attorneys who follow the rule would be at a competitive disadvantage to someone who didn't follow the rule. So the Supreme Court went beyond just looking at the agreement between attorneys as far as, their discussion on the purpose for the rule. What's your response to that? Why shouldn't this court be concerned about that?
Two things, Your Honor. One, we look to the comment of the rule, and the comment explains that during the approval process, the court is only looking for evidence of a co-counsel relationship. And if that exists, then the court isn't really concerned about this.
And what under the commentary, what defines whether they're co-counsel? Doesn't the commentary refer to a disclosure in detail of the performance to be conducted by each co-counsel?
I believe it does, and certainly that might have occurred.
And both the petition and the contract were totally void of any discussion of that, right?
But there was a hearing where the contract was discussed. I believe it was reviewed in camera that Mr. Harmon attended. There wasn't any record evidence about what specifically was said at the hearing, but whatever was said, the trial judge in the personal injury action did approve the contract, in spite of these deficiencies that Your Honor points out. But the commentary says that if a co-counsel relationship exists and then the court authorizes the fee division, then the court doesn't have any responsibility to review or approve the specific amount of the fee division agreed upon by the lawyers and the client.
Once the parties disclose in detail the performance, the actions to be taken by each co-counsel. So here, there's nothing in the agreement or nothing in the petition.
Well,
And how can the judge perform that role?
the record would be incomplete because there was a hearing and we don't know for sure what was said at that hearing. But just here's what the actual evidence was about
Counsel,
how
before
Gerber
we do
did
that,
provide.
just as a matter of law, does the holding in Chandris that if a fee contract violates the rules of professional responsibility, it's void as unenforceable bind us in this case?
Well, no, Your Honor, because our actual fee contract did comply with Rule 4-1.5 F2. And I touched on this in the supplemental brief. And the Katz case is probably the better analogy.
So is your best argument that the employment agreement complied with the rule, the Weissman addendum didn't comply with the rule, and the court approval process via petition just doesn't matter?
Well, it's not that it doesn't matter. It's that the trial court still had the discretion to approve or to deny the petition to approve the contract. And exercising that discretion, the trial judge in the personal injury action did approve it. We cited a couple of cases.
Does the trial court exercising its discretion immunize the petition process from review? I don't think that's what the rule says, right?
No, the rule doesn't say that. But the point that I was trying to make is that no court has ever invalidated a contingency fee agreement because of errors in the approval process itself. The Wright versus Ford case that we cited from the Middle District of Florida in 2013 was on this exact issue, that the contingency fee petition in that case had the same failures that Judge Evander pointed out in this case. And in spite of that, the court approved the contract, find that those failures did not render the petition void under the Chandris decision, because Chandris didn't require the court to invalidate the fee split, despite of errors in the approval process. It still had the discretion. Now, contrast that with the Katz case, where it's the contract itself which is invalid. And in Katz, the evidence was that the contract wholly failed to comply with Rule 4-1.5 F2, and that the lawyers actually didn't have a contract with the clients at all.
What would be a situation, because I understand you're arguing materiality, what would be a situation in your estimation in which the petition process, assuming a petition was actually filed, would meet that threshold? What is not enough?
Well, if the court denied the petition, then that certainly would be not enough. And that would actually, anytime a petition is denied, you're supposed to report it to the Florida bar, and then presumably that starts a whole nother proceeding to see whether or not the judge or whether or not counsel was doing something amiss in violation of the Florida bar rules. But
was there a basis legally to deny the petition that was submitted in this case?
Well, I mean, all of the deficiencies that Judge Evander mentioned, I guess the court, if they were of the view that Chandris required strict compliance with every requirement of Rule 4-1.5 F4D subsection 3, then the trial court could have. But the evidence was, and what I want to get back to, is that there was substantial equal active participation here. So Gerber had been representing the clients for 18 months before bringing Harmon onto the case. Gerber already had a court-approved contract. And under that court-approved contract, Gerber was charging 62.5% of the 40% fee. It was court-approved, and there's no question about whether or not the approval process in that contract was appropriate. It was. When Harmon comes on as co-counsel, Gerber was reducing Gerber's fees from 62.5% to just over 50%. And Gerber didn't need court approval to charge more than 25% of the fees, because Gerber already had court approval by complying with the entire process from the first contract. It was Harmon who needed court approval.
Well, Mr. Steinberg, if, for instance, Harmon was hired one day after Swope had been hired, Swope was discharged one day, does that mean because she had complied for one day with the other contract that, that you didn't have to do anything further under the Harmon contract? Because, that's what I thought you said, is that because she complied under the Swope contract, she was good to go.
But Gerber had the case for 18 months and was
Right,
responsible.
but 18 months, I mean, theoretically, you could do 1 hour of work in 18 months. So I'm not sure where where the fact that she complied with the contract under SWOPE necessarily means that she's good to go with the contract with Harmon.
Well, remember, we're only talking about presumptions of excessiveness here, and the presumption of excessiveness is removed if the secondary firm, the firm accepting secondary responsibility, is assuming substantially equal active participation. And the
Where
evidence,
did that occur in this case?
the evidence was undisputed that
In writing, where did that occur?
where did what occur? The
And
substantially
Ms.
equal.
Gerber accepted substantial equal participation.
Well, it occurred in the both petitions, the petition to approve the Gerber SWOPE contract, which was properly approved, and then in the petition to approve the Gerber Harmon contract. And
Which she didn't sign.
which she didn't. But the question isn't whether or not there was substantially equal active participation in writing that was promised. The question is whether or not there was actually substantially equal active participation.
Was the jury given that option to find that, or was the jury just instructed on accepting responsibility, joint responsibility?
The jury wasn't given any of these Florida bar rules. And let me just address about this notion that the jury could somehow cap Gerber's fees at 10%. I mean, at 25%. There was no basis for which the jury could have done that. The jury didn't know anything about what the law was on this. They didn't have any jury instructions. And of course, the jury instructions is what gives the law. But damages wasn't even a proper consideration for the jury, because we'd moved for directed verdict on the $390,000 in damages at the end of the defendant's case before the verdict. And then after the verdict, the court recognized it should have granted our directed verdict to begin with, that there should have never even been a damages question to the jury, because we're governed by the terms of the contract. And the contract said that Gerber was owed $1.67 million.
So if the jury's not called upon to determine compliance with the rules, then who is? Would it be the court?
It would be the trial court, but Harmon's not asking for a remand for the trial court to do that. Harmon's asking that this court sit as fact finder and determine whether or not there was a clearly excessive fee. And of
Would
course,
it be only the trial court, or could the appellate court review it like they did in Katz?
well, but I don't believe that on this record that it would be appropriate for this court to make these determinations, because the issue wasn't fully litigated. And in Katz, it was so obvious that there was no contract at all. Of course, in that situation, it wouldn't be appropriate for the court to permit the contract or the parties to recover under the contract, because there was no contract, which is different from our situation.
All right, sir, your time is up. Mr. Martinez, you have 1 minute.
Thank you. In terms of an evidentiary basis that she was capped at 25%, that's at the record 3038 to page 340, where she testified to that effect to the jury. In terms of the other record citations for Judge Sasso, they were at, I'm going to read off a string of numbers here, 2940 to 2941, 2949 to 2951, 2960, and then page 3045 and 3046.
Thank you.
Anything else?
That's it, Your Honors. Thank you for your time.
All right, thank you both. Court will be in recess.
Thank you.